To another edition of Matters of Law. Matters of Law, the law reigns supreme. Connect with us on extvgh on YouTube and extvgh on Facebook. Today, we are discussing Contract 2. Let's go for a spot of commercial and we'll be right back.
This program is brought to you by PEG Enterprise. Call us on 0240 533 097. 0240-533-097 for your delicious pastries, cookies and drinks. Locate PEG Enterprise near KK House in Ho.
Welcome back. We are discussing the law of contract 2. In our episode 23, we discussed law of contract and we received a lot of comments and a lot of questions from you. Some of you felt there were some things we were supposed to touch that we didn't touch. So we'll try to do a brush up of some of the things, a little bit of some review, and just do a little bit of some elaboration. This video is going to be a lot longer than the usual ones that you are used to. So please do prepare and stay so that you will learn a lot from this particular episode. So law of contract. Obviously somebody will be asking what the contract is and what the Contract Act is. So our Contract Act is 1960, Act 25, and the Contract Act governs how contracts are supposed to be entered into, what one is supposed to do and what one is not supposed to do under our Contract Act. Now the basic requirement of somebody who asks is, what is a contract? Obviously a contract is an agreement between two or more parties which is supported by consideration, and that contract is considered also as legal for you to be able to enforce it. So it's important to know who and who can enter into a contract. Now, the parties who can enter into a contract brings us to the question of determining capacity to enter into a contract. Under the Contract Act, one has the capacity to enter into a contract if the person is of sound mind and is 21 years and above. That means that the person would have to attain the age of 21 years to be able to have the legal capacity to enter into a contract. But the Children's Act mentions an adult or somebody who is an adult as considered from 18 years and above, and a child is one below the age of 18 years. So by virtue of the Children's Act and by virtue of our constitutional mandate to be able to vote at the age of 18, there is an understanding that from 18 years and above you have the legal capacity to enter into a contract. Now there are exceptions to this particular issue of capacity to enter into a contract. So somebody will ask, so if a class 4 pupil who is about 8 years goes to a shop that he wants to buy a pencil, or he wants to buy a pen or a masset, are we saying that a contract has not been entered into? Yes, a contract has been entered into at that point. Now, anybody below the contractual age who enters into a contract, the question we need to ask ourselves is that, does the person have, is it a necessary of life for the person? So if an 8-year-old and 9-year-old goes to buy food and pays money for it, that particular 8-year-old or 9-year-old has entered into a contract, and that is validly so because the person has made payment for it and it's correct. Now, should an 8-year-old go and enter into a contract to buy, let's say, a car? Obviously, an 8-year-old cannot enter into a contract to buy a car. One, it does not even have the legal requirement to be able to drive that vehicle, and two, the car is not a necessary of life. And by car, I don't mean a toy car, I mean a car that one can drive on the road. So that's the issue of the capacity of parties to enter into a contract. Now we'll look at issues of intention to create legal relationship. Is it every contract that there's an intention to create legal relationship? No. Ordinarily, business contracts, their intentions to create legal relationship. By business contract, I'm talking about people who are transacting business at arm's length. They are the same level. Such transactions, there is an intention to create legal relationship. There are exceptions, however. There are certain transactions between husband and wife, siblings and others, where the law considers them that there is no intention to create legal relationship, except there is a manifest intention which has been manifested or has been exhibited by the parties who are entering into a contract, that this particular contract, we intend that it be bounded by law, or that it can be taken to court if one person breaches the contract. So it is possible that a husband and wife can enter into an agreement which has legal backing, or there's an intention to create legal relationship. Intention to create legal relationship simply means that one party breaches the agreement, the other party is entitled to take that person to court to ensure that the agreement is enforced. So husband and wife, people who belong to social clubs, siblings can actually enter into an agreement. You can sell a land to your brother and there will still be an intention to create legal relationship if you both decide that that is exactly what you want to do. So it's important for us to understand that when you have the offer, when you have the acceptance, and when you have the consideration, which may be money, which or any other thing that is in kind, one is of value, we are looking also at the capacity for one to enter into the contract. Now, it is important also to state that when we are discussing capacity, we also talk about the fact that you should have sound mind. Sound mind meaning that you understand everything that you're going to enter into. One who does not have sound mind cannot enter into a contract. So the person's mind must not be affected by insanity. So having discussed the issue of capacity and discussing intention to create legal relationship, then what we should ask ourselves is that issue of legality. So if you want to find out whether a contract is legal, then you're asking yourself, does the agreement that you are entering into, whatever you are entering into, does it comply with the laws of the country? Obviously, you cannot enter into an agreement to deal in any business which it is outlawed. If the business is outlawed or that agreement is outlawed, then obviously you cannot bring that matter to court because whatever you're going to do is outlawed. So there must be legality of whatever transaction that you are entering into. For example, if you enter into an agreement with someone that the person supplies you cannabis and the person does not have the necessary authorization from the necessary authorities, then that agreement that you are entering into already is illegal. You cannot enter into an agreement for somebody to smuggle an item to you and you say, oh, it's bounded by, because you agreed to put it on paper, it's bounded by law. It is also important for me to say at this point in time that there are certain things that will make a valid contract, will detract from a valid contract. By that I mean, if somebody makes a misrepresentation or somebody tells you something and the person knows that whatever he or she is telling you is false, that is fraudulent, or somebody makes that representation knowing very well that he or she is being reckless or has not made checks on it, then certain defenses will kick in, for which one can exercise his rights under the law to ensure that he or she gets the necessary remedies to be guaranteed under the law. It is important that if you do not understand anything, you speak to a legal practitioner to get the necessary basis. One other thing people ask is that, must every contract be written? No, every contract must not be written. However, there are certain specific contracts that the law requires that they are in writing. For example, an insurance contract or a contract to get an interest in land that is beyond 3 years. Yes, so if you want to buy land, you want to lease a land, and the term of the lease is more than 3 years, the requirement of the law is that it must be on paper. Can you remember or can you think of other contract that you enter into that necessarily you don't go to pay, or it goes on paper? For example, when you're buying tomatoes in the market, or you're buying a tin of milk in the shop, or any other thing like that. It is a contract that you enter into with the shop owners or with whoever is selling to you, but you do not put that on paper. In fact, if you do not put that on paper, it's still valid. Now the question is, so how do I prove when I go to court? Obviously, you can need oral evidence, parole evidence. Now, having discussed or having mentioned parole evidence, I would want us to just look at what parole evidence is. So on parole evidence, the law ordinarily prevents you from bringing in oral evidence to vary the terms of a written down contract. The oral evidence would only be admitted if the written down document does not make sense or it doesn't really add up. So then parole evidence may only be admitted to be able to make the contract make sense. Thank you so much for watching this edition of Matters of Law. We have been talking about Law of Contract 2. In this particular edition, we discuss capacity to contract, we talk about illegality, we talk about intention to create legal relationship, then we discuss a little bit on parole evidence and illegality in the contract. Join us same time next week on Matters of Law. Matters of Law, we say the law reigns supreme on extvgh on YouTube and Explore TVGH on Facebook. Thank you.
To support this program, contact XTV on 024 606 1095 or 050 836 4159 or send us an email to info@extvgh.com.